This is a part-heard appeal in the matter of VietJet Aviation, Joint Stock Company and FW Aviation 1 Limited.
Good morning, Mr Smith.
Good morning, my lady. Just to do with one point of housekeeping first, we've crunched the numbers and we've worked out that we have until 3:25 p.m. Today, which will leave my little friends 50 minutes in reply, assuming a 4:15 finish. So we'll aim to sit down by no later than 3:25.
I'm very grateful for that. I was going to ask you.
My lady, the second point is in relation to the request for the LMA materials. We've prepared a short clip. We've made copies available to my learned friends. Perhaps if I can hand that up and I'll just explain
Very grateful.
what's in there. Hopefully they're slightly better organised than the documents we handed up yesterday.
Thank you.
And the intention is these can just go at the back of the authorities bundle. So we've numbered the tabs. So just to explain what we have, the first document, tab 33, is an extract from the textbook, Practitioner's Guide to Syndicated Lending. And you can see at 243, there's just what might be some helpful context. Said that syndicated loan agreements in the European market often contain restrictions on a lender's ability to transfer its rights and obligations to a third party. Traditionally, syndicated loans were drafted so the lenders would always be banks as transfers to entities other than banks, or later, financial institutions were not permitted. The categories of potential transferees have been expanded over time, initially as a result of funds buying distressed sovereign debt claims, and more recently to accommodate the arrival in the secondary loan markets of hedge funds and CDO or CLO special purpose vehicles, which in my submission supports what we were saying yesterday about the purpose of the expansion. And then current LMA documentation, potentially eligible transferees are any bank or financial institution, trust fund or other entity, and it continues, and that's the familiar wording. The second document is the guide to the LMA investment grade materials, which is produced by the Association of Corporate Treasurers. In fact, I think Slaughter may produce it on behalf of the Association of Corporate Treasurers. And if you go to 295, it deals with changes to the lenders. And if you go over the page, 296, the text in the highlighted coloured text is helpful, because the comment is the 2006 decision of the UK Court of Appeal made clear that to qualify as a financial institution in the context of a loan facility, an organisation need only be, and then it obviously picks up the text from paragraph 51 of Lord Justice Old. In particular, it's not necessary that an organisation's business should include bank-like activities, thus even if the class of permitted lenders is restricted to banks or banks and financial institutions, it will remain very broad. And you can see it in the footnote 20 is the ESAR case. And then this is the current edition, of course, of the ACT guide. And then if you go over to the next tab, we've put in an extract from the LMA standard form itself. Now, I should say, just by way of explanation, that these days there are in fact myriad LMA standard forms for sort of almost every different type of loan you can imagine. But this is one of the investment grade ones, and there isn't a material difference in this wording between any of them. And if you go to the second page of the tab, it's clause 26, and you can see the standard wording there reflected in the agreement in our case, just underneath A and B in 26.1. So that I think shows you that is the standard form LMA wording. And then the final document is the Encyclopedia of Banking Law, which is the extract the judge referred to at paragraphs 236 and 237 of the judgment. and the relevant part of that is on the second page of the tab towards the bottom of the page, transfers only to financial institutions. And then over the page, and again, this is what the judge referred to, you get the reference to Argo against Esar Steel. And as they said there, and this is something I think the judge picked up, the lesson of this decision is that the courts favour the marketability of assets and will therefore construe restrictions on transferability very narrowly. If the borrower wishes to limit assignees to commercial banks who are able to lend, it's considered that this would have to be specifically stated.
Thank you.
And in our submission, all of that supports our submission that the concept of financial institution is very wide indeed, and effectively that simply follows from what this court itself decided in Esar, and that, unsurprisingly, is the basis on which, in our submission, the markets have proceeded since. Now, just going back then to where we were yesterday, I was dealing with my little friend's second proposition, which is that even if he's right on his mutual exclusivity point, he's not right to say that we fall outside the financial institution bucket. And I'd made the point yesterday by reference to Esar itself. We say the definition in Esar simply applies. There's no reason to think it wouldn't apply. And I took you to the clear Vulas and paragraph 28 of that. And we say that principle of construction explained there is applicable here. The other case that's worth looking at in our submission on this point, as demonstrating the width of the concept of financial institution, is the Olympia Securities decision, which you have in the authorities beginning at page 511. So this is, sorry, it begins at 503, it's tab 19. A decision of His Honour Judge Pelling. If we go to 504, just to explain the background, in the context of the 2008 financial crisis, obviously a number of banks fell into difficulty. One of the banks that fell into difficulty was an Irish bank called Anglo-Irish Bank. It ultimately went into insolvency. One of the things that happened was essentially a portfolio of its assets was bought by a hedge fund called Lone Star. And as part of that, the particular loans which were the subject of this case were transferred into the name of a vehicle called WDW. And the question was, well, is WDW a financial institution such that it is permitted to take a transfer of the relevant instruments? And if you go to paragraph 7 on page 505, you can see what WW was in broad terms. I mean, and essentially it was a special purpose vehicle. It was set up by way of incorporation on the 2nd of May 2014. And as you can see from the preceding, the final sentence of the preceding paragraph, that was actually after the sale transaction had been agreed between IBRC and the Lone Star entity, which was called Lesref Free White Limited. So that was entered into on the 16th of February. Then on the 2nd of May, WDW was incorporated and it had a share capital of simply £1. And then subsequent to that, effectively the earlier portfolio sale transaction was completed by way of transferring the rights to WDW. Now, the contention that was put was WDW isn't a financial institution. If you go to paragraph 11 on 506, you can see the judge identified the issue at paragraph 11, which is whether WDW was a financial institution. And then in paragraph 12, he set out the relevant language, which in 23.2, in the 5th and 6th lines, included the banks or other financial institutions formulation. And then if you go on to paragraph 17 on page 508, you can see the argument that was put by the opposing party. In that case, it was submitted on behalf of Arazim that to be one of the financial institutions to which IBRC was permitted to assign, the entity concerned had to operate on its own behalf in the field of regulated finance. It was submitted that WDW failed this test for 2 reasons. First, because it was non-trading at the time when the assignment took place. Second, it didn't operate in the field of regulated finance, either before or after the purported assignment, because its only purpose was to hold assets on trust for a third party. And then, perhaps unsurprisingly, WDW submitted, well, that's too narrow a construction of financial institution. Look at Argo Fund and ESAR Steel, as we've been doing. And then the judge set out, spent some time going through Argo and ESAR Steel. And then if you get to paragraph 20, on page 511, he said this: I accept that in a technical sense, the conclusion of the majority of the Court of Appeal is not determinative, because that case was concerned with construction of a phrase using a different commercial context and a different contract from that which arises in this case. That said, the differences are slight. The issue in Argo concerned the ability of a primary lender to assign or novate its interest under a syndicated loan agreement with a commercial borrower, whereas in the present case, the issue concerns the ability of a primary lender to assign its interest under a commercial loan agreement with a commercial borrower. There's no distinction of substance between the two situations that leads to the conclusion that the meaning of the phrase financial institution should be wider in one case than the other. And then he then proceeds in paragraph 21, then effectively to say, well, it's appropriate to proceed on the basis that financial institution bears the meaning established by the Court of Appeal in Argo. And he concludes at the end of 21, in my judgment, it's in principle wide enough to include WDW, subject to the points I considered below. And then he deals at 22 with the submission that it couldn't in any case include what was called a £1 company and the fact it was non-trading. And he disposes of those points in 23 and 24. And so far as the capitalisation is concerned, essentially he makes 2 points. I mean, firstly, well, what is the test for the amount of capitalisation which is required? That's not spelt out. But then just above the first hole punch, he makes this point as well. It would have been simple for parties who wished to limit the scope of financial institutions raised a corporation with a minimum capitalisation to do so by express provision, but the parties have chosen not to do so. And then on that basis, he rejects the idea that financial institution has within it some notion of a minimum capitalisation, whatever that amount might be. And then 24, he also rejects the other point, which was the argument that WDW wasn't trading at the time when the assignment took place. And in my submission, his reasoning there is quite is compelling, and it deals, amongst other things, with the SPV example which we were discussing yesterday. And as he says just above the second hole punch, as was posited in the course of argument, if correct, Mr Morgan's proposition would mean that a newly formed corporate entity wholly owned by a multinational heavy capitalised commercial bank would not be a financial institution before it entered into a nominal £100 transaction, but would become one thereafter. Such an approach is entirely artificial. And in my submission, he's right about that. But fundamentally, I mean, that is, in our submission, a very good example of the wide definition of financial institution established in ESA being applied by a judge quite correctly in our submission in relation to transfer provisions in similar loan agreements. And in particular, it deals, I think, with the point which was discussed yesterday about where does an SPV established for the purposes of a transaction fit into this. And in our submission, the judge in that case was right to conclude that the SPV was capable of falling within the rubric of financial institution for the reasons which he gives. So our first point, as I say then, ultimately financial institution bears what we would say is its normal meaning. The second point is just going back to the language of 17.1.
Sorry, he also deals with the regulation point or lack of regulation.
He does.
At 25 and 26.
He does, exactly, yes, he does.
Sorry to interrupt you.
No, not at all. I'm going to come to that point because in fact we say we are regulated, but this is, but you're absolutely right. He doesn't regard that as a requirement either. So I was going to just go back then to 17.1 and just make the point on the language in relation to that, which we did in fact touch on yesterday. So 17.1 is back in the supplemental bundle at 272. And in our submission, when you look at that language, and even assuming my learned friend's right in his mutual exclusivity point, a trust, fund, or other entity in our submission doesn't capture a company. And there's two main reasons for that. The first is a company is perhaps the most obvious form of entity. And if that formulation had been intended to capture a company, it would inevitably have said so. I mean, why pick out trust fund or other entity but don't mention company when company is quite plainly the most obvious form of entity which there is? And then the second point is when it refers to trust fund or other entity, the other entity is, in our submission, referring to things that are similar to a trust or fund. So unincorporated entities, things in the less conventional legal form where there might be room for argument about whether it's an institution, a financial institution at all. So it's intended to capture perhaps the less conventional forms of vehicle. But if you have a company which is engaged in the field of commercial finance, well, that falls within the financial institution rubric and not within that that further additional language added at the end of the clause. Now, and you have the point that in our case, FWC is a company incorporated in England. Now, the third point is then to put the matter around the other way and ask oneself, well, how does VietJet define financial institution on its case? In our submission, contrary to my learned friend, it's necessary for VietJet to address this because it has to explain, as part of its appeal, why my client does not fall within the term as it defines it. It can't simply dodge the point, as my learned friend seeks to do. In fact, VietJet hasn't addressed this point. It didn't address it in its skeleton argument for the appeal. The most we've got from my learned friend's oral submissions is a reference to a footnote in its closing submissions for trial. If you go to tab 19 of the supplemental bundle at 1374, and all you get is this in the footnote. They say, however, such entities would no doubt share at least some and perhaps all of the key characteristics of banks, being commercial lenders of a certain size and substance and subject to regulation. So it seems that they identify 3 characteristics of a financial institution. You have to be a commercial lender, be of a certain size and substance, and be subject to regulation. Now, the obvious question is, well, why are those requirements of being a financial institution? So far as the first is concerned, why is being a commercial lender a requirement of being a financial institution? That's just a particular type of financial institution. There's lots of financial institutions that don't engage in the business of commercial lending themselves. And in Asplin, it's just assertion to say that that is a requirement. The next formulation of a certain size and substance, with respect to my little friends, I mean, that is just a meaningless collection of words. When you say something is of a certain size and substance, I mean, it's effectively meaningless. I mean, that can only work as a condition if you identify what the objective criteria are in relation to size and substance. To say something has to be of a certain size or substance is in effect meaningless. It goes back to Lord Justice Ricks's criticism in Argo, how long is a piece of string? It's the same point. And then subject to regulation, again, why? Why does an entity have to be subject to regulation in order to be a financial institution? It just comes down ultimately to assertion. But in any case, the point is also this. FWC does have regulated directors. The 2 directors it has, Mr Brazil and Mr Gray, are both regulated by the FCA. And FWC is of a certain size and substance in our submission, not least because following the transaction, it held $138 million of loans. Now, just on this point, just so you're aware of the context, the position at trial procedurally was that VietJet didn't advance a positive case going into trial as to whether or not FWC was a financial institution. It just didn't, there was a non-admission on the point. So this case, which is put here in the footnote about what financial institution means, was only advanced for the first time in closing submissions by way of this footnote. And it's for that reason that the evidence at trial doesn't squarely address this point, because if this had been put up at the start going into the trial, well, this VietJet says is its test for the definition of financial institution, that would have been met squarely on the evidence. It wasn't, because VietJet simply put in a non-admission on that point. And this formulation, it was put in a footnote in closing submissions. It's not picked up in the skeleton argument on appeal, and then is effectively revived by my learned friend orally. But as we say, I mean, A, it's wrong. There's no support for it. But B, even if it was right, we say we would meet it, subject to the commercial lending point. I mean, I accept FWC isn't a commercial lender, but as I say, I mean, there's no basis at all for saying that's a requirement to be a financial institution. I mean, if that was a requirement, then I don't see why financial institutions and banks wouldn't be synonymous, really. Now, so for all those reasons, even if my little friend was right on his first proposition, he doesn't get anywhere on his second proposition. And we are a financial institution. Now, just to wrap things up, we've obviously addressed clause 17.1, which, as I say, is really the foundation of my learned friends' submissions. It's on that basis you then have to look at the definition of qualifying lender, which is in clause 9.1 at SB 248. And my little friend took you to this. and it's lim Roman numeral 3 of the definition, which is relevant for our purposes. And of course, the reason why we spent the time on 17.1 is he seeks to found his case on the fact that the wording trust fund or other entity doesn't appear in lim 3. So effectively he's saying, well, all the categories are mutually exclusive. You're in the trust fund or other entity bucket. So by the time we get to lim 3 of this, you fall outside that because by definition, you're not in the financial institution bucket. In our submission, that's wrong. We say we're simply within the financial institution bucket. Firstly, financial institution here must bear the same meaning as in clause 17.1. There's no basis for thinking that the same term should bear a different meaning within the same agreement. So if we're right, and we say we are, that financial institution bears the normal ESAR meaning in 17.1, then it should bear that meaning here as well. That's the first point. The second point is that it's far more likely that if the parties had intended the meaning of financial institution in lim 3 here to be narrowed, then they would have included express language to that effect. And that was the point, one of the points made, as I showed you, by His Honour Judge Pelling in Olympia Securities by reference to the capitalisation point. And it also goes back to the point that ESAR, in my submission, was a highly significant decision for the secondary debt markets on the meaning of this very term. And if the draftsman had intended to deviate from the ESAR meaning here, it's far more likely that he would have said something specifically to that effect rather than simply left the term in there in exactly the same form that the Court of Appeal had opined on it in ESAR.
Do you support the judge's conclusion that it's here being used just as a shorthand for the whole of 17.1, or do you accept that it is potentially narrower in that it excludes those who could only come within the additional wording?
Yeah, I mean, this is going to be my third part. I think there's two possible explanations for the reason you don't see the trust fund or other entity language. The first is it's just a slip and it has fallen out of the drafting. Now, that is not, wouldn't necessarily be at all surprising because you might recall that by reference to clause 7.6 of the same agreement, just a few pages earlier, at 245, my learned friend accepts there is a slip there in essentially the same provision because the word bank has been omitted. And if you recall that on 245 at 7.6,
it just says financial institution,
exactly.
Trust fund or other entity.
Exactly, and we drew attention to this in the footnote 16 of our skeleton, and my learned friend accepted in his oral submissions that this was an oversight and the word bank had just slipped out there. I mean, that's obviously right. So it wouldn't be entirely surprising if there had been a slip. I mean, the alternative is my Lord's explanation, which is the other way of looking at it, which is there was a conscious decision to say we're going to limit this in 9.13 to the more conventional forms of entity, like a company, and exclude the more unusual forms of entity, like trust funds and other vehicles of that nature. And either of those are plausible explanations. It doesn't matter for our purposes because we say we're simply within the definition of financial institution, whatever the reason for that wording not being there. It matters not to us because we're in financial institution. We're not in the bucket of trust fund or other entity. So those are the two possible explanations, it seems to us, why you do have that difference in the wording. Now, the other point then to deal with is 21.23 because, as you appreciate, the other relevance of this issue is not just in relation to the transfer of the lending, but also in relation to the appointment of the security trustee. And this is in 21.23, which is at 299, and it goes over to 300. And you can see in 21.23b, there's two limbs to it, Roman numeral 1, and then at the top of the page, Roman numeral 2. In fact, they both contain the same formulation. But for the court's note, it was limb 1 that was applicable in the present case. So the appointments in this case were made pursuant to limb 1. Now that says trust, corporation, bank, or financial institution. And again, we submit that financial institution there simply bears its normal meaning and bears the same meaning in as in clause 17.1. And there's a further point to make as to why VietJet's argument is also particularly lacking in credibility when you come to 21.23, because its argument, as you appreciate, is founded on 17.1 and drawing certain conclusions from 17.1 as to what must have been meant by financial institution. That's its basic building block. But of course, 17.1 is dealing with an entirely different issue to 21.23. 21.23 is concerned with the identity of the security trustee, not the transfer of lending from one lender to another. And we do say it would be particularly odd if the meaning of financial institution in the context of appointment and retirement of the security trustee bore a special limited meaning, which one was somehow supposed to derive from a provision elsewhere in the agreement dealing with an entirely different subject matter. I mean, if you just put yourself in the position practically of a lawyer who's advising on the appointment or retirement of a security trustee, you come along, you look at this provision, you see it refers to financial institution, you think, well, that's not a particularly controversial term, we know what the Court of Appeal has said about that. So fine, I apply Lord Justice Hull's definition. On my learned friend's case, what the lawyer should have done is realised from the way 17.1 is constructed that actually financial institution in the context of 17.1 bore a special, more limited meaning, and then transposed that into 21.23. And in our submission, that is just utterly unreal. It's entirely impractical. That's not how the way. That's not the way the commercial world works, or people go about operating the mechanics in these sort of agreements. So that's an additional reason, if you like, why this argument doesn't work when you come to 21.23. Now, one of the other points, if we go back to 17.1, one of the other points VietJet makes is to say, well, 17.1 and 17.2 are dealing with two different situations, which is true. 17.1 is dealing with the situation where there is consent from the borrower. 17.2 is dealing with the situation where there isn't consent from the borrower. And VietJet says, well, as a matter of commercial sense, you'd expect the universe of permitted transferees to be narrower in 17.2 than it is in 17.1, because in 17.2 you're in the non-consent scenario. And that's a sort of commercial point it makes. In our submission, that isn't a good point, because we know that on any view, the definition of qualifying lender was narrower than the definition of existing of new lender in 17.1, and that's because if you go to 17, if you go to SB 248, within the definition of qualifying lender, there are other requirements that an entity must meet in order to be a qualifying lender, and those are obviously specifically focused on the tax position, which, for reasons you'll appreciate, was, I think, the key overriding concern in relation to this structure. So the definition of qualifying lender is narrower because of the additional requirements that you get in Roman numerals 1 through to 3 of the definition of qualifying lender. And commercially, it makes perfect sense because the way 17.1, 17.2 work is either you can do the transfer with consent under 17.1, in which case the borrower is presumably in a position to make an assessment of whether the new lender is one it wishes the loans to be transferred to, or it can be done without consent of the borrower, in which case you have to tick the boxes of qualifying lender, which includes the various tax requirements. And in our submission, that makes perfect commercial sense in relation to this transaction and doesn't depend in any way on reading down financial institution when it appears in 9.1 lim 3. Now, so that point isn't in our submission a good point. So far as the replacement of security trustee is concerned, in our submission that's a matter that primarily affects the lenders rather than the borrower, particularly given the limited recourse nature of the facilities. It's actually the lenders who have the main interest in being happy and content with the identity of the security trustee. And if you go back to 299, you can see the way in which that works is it does reflect and respect the interest of the lenders in the identity of security, in the identity of the security trustee, because under lim Roman numeral 1, the replacement security trustee has to be nominated by the instructing group. So that's effectively the majority lenders. Or under Roman numeral 2, if there isn't a nomination from the instructing group, it has to be nominated by the security trustee itself. So the universe of entities that can be the replacement security trustee is heavily circumscribed in a way that makes commercial sense by reference fundamentally to the views and interests of the lenders. And again, none of that depends on reading down financial institution in any way. The real limitations reflecting the commerciality of this are those driven by the interests of the lenders. So, unless the court has any questions for me, that concludes what we're going to say on ground 2. I'm going to shift to my right. Mr. Peacock's going to take my place, and then I will rise once Mr. Lissak's finished to deal with the respondent's notice. Thank you.
Thank you very much indeed. Mr. Peacock. 3 and 4.
3 and 4. Well, my lady, my lords, it's a rare case in this appeal where the interpretation of the UK-Japan double tax treaty might seem like light relief. I'll try and make it as light as I can.
Maybe.
So ground 3, I'd like to start with the treaty, if I may. I know you've seen it briefly, but I just invite you to turn it up. It's in the authorities bundle at tab 3, page 8. And in particular, starting at page 9, there are in effect the heading and the recital to like effect, the purpose and object of the treaty is the avoidance of double taxation and the prevention of fiscal evasion. So as between the two contracting states, you're trying to avoid both double taxation and double non-taxation. You were shown briefly Article 3(1) little l, that's on page 11, which extends the definition of business so as to include the activities of the self-employed, but the term is not otherwise defined. You were shown briefly Article 3(2), which appears on page 12, which directs you to look, in the case of any term not otherwise defined, to the relevant domestic law, being the relevant domestic tax law in each case. So here we're concerned with the reliance on the treaty by a resident of the UK that is asserting under Article 11 the right to receive interest gross. So it is UK domestic law, UK domestic tax law that is relevant. Come back to that. Then rolling on, you were shown Article 11. 11(1) seeks to allocate taxing rights in the case of interest received by a resident of one of the contracting states, provided that it is the beneficial owner of that interest. And in such circumstances, that person would not suffer local, i.e. here Japanese, withholding tax. Now, it is not said against FWC that it's not the beneficial owner of any interest. So we meet that condition, but I accept that's a sufficient, it's a necessary condition, but not a sufficient one. You were shown 11(7), that's relevant to ground 4, the main purpose test. I'll come back to that in a little while. And then you were shown 22(1), with the special list of qualified persons. I'll come back to in a moment. And then the extended protection in Article 22(5). But picking up a point you heard from a learned friend, Article 22(5) applies in the case of income under Articles 10, 11, 12, and 13, so 12 and 21, and also capital gains under Article 13. So when we come to the meaning and scope of Article 22(5), we have to read it in the context of the treaty as a whole, point I'll come back to. Now that treaty is the product, no doubt, of careful negotiation between the contracting states, each of which, of course, has a significant financial centre, London and Tokyo. So that's the treaty. The relevant principles we are concerned with when interpreting a treaty of this nature. You were shown Royal Bank of Canada, a very recent decision of the Supreme Court, and the judgment of Lady Rose. Royal Bank of Canada in the authorities, tab 27, page 700, and it's her ladyship at paragraphs 27 to 33, being pages 709 to 710 of the bundle. Now that concerns the UK-Canada treaty, and it is the latest word on treaty interpretation. Her ladyship refers back to Anson and to Fowler. I'm not going to invite you necessarily to turn up these references, but I want to give them to you. So Anson's a case about the UK-US treaty, decision of the Supreme Court. It's in the authorities bundle at tab 16, page 391. And Lord Reid gives valuable guidance on treaty interpretation, paragraphs 54 through to 57, and paragraphs 110 and 111 that are later picked up in the authorities. The court will be aware, and we saw briefly yesterday, that like all international treaties, double tax treaties are governed by the Vienna Convention on the Law of Treaties. And Articles 31 and 32 of that treaty prescribe rules by which international treaties should be interpreted, and they're set out by Lord Reid in those passages. Relevantly for today's purposes, there's a discussion in Anson, echoing earlier discussions in cases like Fothergill and Monarch Airlines way back in the day, about what supplementary means of interpretation the court should look at. And that reference to supplementary means of interpretation is taken from the Vienna Convention itself. And the case law establishes, as you might expect, that you can look at judgments of foreign courts, academic writings, such material as you find persuasive. You can also look at the OECD guidance, and that is not limited to the OECD's commentary on the model double tax treaty. There is no such limitation, despite my own friend Mr. Thompson's rather bold contention yesterday. You're entitled to look at any supplementary means of interpretation, provided that you are satisfied that it bears on the interpretation question that you are faced with. So there's no relevant difference for these purposes between OECD commentary on the model treaty and other OECD guidance, provided that the latter bears on the relevant issue. Second authority, again, I'm not sure you need to turn it up, but it's the case of Fowler, decision of the Supreme Court, this time the UK-South Africa Treaty. It's in the authorities volume at tab 20, page 522, and it's Lord Briggs at paragraphs 16 through to 19. And here he specifically discusses reliance upon the OECD commentaries, and that's pages 527 to 529 in the bundle. And then the last case is a decision of this court, Lady Justice Falk, in the GE Financial case, UK-US Treaty, authorities, tab 26, at page 664, and it's her ladyship's paragraphs 36 through to 43, beginning at page 674 in the bundle. Now, I don't understand those principles to be in dispute, save for the point that Mr. Thompson made that one should look at the commentary on the model treaty, but not at other OECD guidance. I'm afraid he's wrong about that. There's no such limitation. So the principles with that proviso are common ground, we think. Treaties obviously need to provide, in the case of interest, for taxation either in the state of source or in the state of residence. And nearly all of the UK's tax treaties allocate taxing rights either solely to the state of residence, or they accept that there'll be taxation in both states, but typically with a cap on the withholding tax in the state of source. So it may be that interest can be taxed in, let's assume Japan, but at a capped rate of 5% or 10%, and then it's also taxed in the state of residence here, that would be the UK. Now, our particular treaty doesn't adopt that technique. It provides instead that there shall be only taxation in the state of the recipient and no local withholding tax in the state of payer, here Japan. And avoiding the local withholding tax means that there need be no provision in common loan documentation for any gross-up clause. Now, as the court has seen, Article 22 is a qualification on, amongst others, Article 11, so that Article 11, or the benefit of Article 11, is only enjoyed by certain types of person. And those are the persons listed in Article 22, that's subparagraph 2. Can I invite you to turn up that paragraph in the present treaty? It's in the authorities bundle at page 26, which identifies those entities that will be qualified persons, and then there is a list from A onwards, and they are listed by reference to the type of person. You can be an individual, a government entity, listed companies, C, unit trusts, D, pension funds, E, charities, F, and then subsidiaries of a body that is otherwise qualified, G, and then the last one is trusts that are majority owned by an entity that otherwise has qualified. So you are ensuring that the benefits of the treaty, here as regards Article 11, are available to certain categories of person. What Article 22.5 goes on to do is to say, well, even if you're not within those categories as a qualified person, the treaty can still be available to you, provided you carry on a particular type of business. So we've moved from Article 22.2, that looks at the nature or status of the person, to Article 22.5, which is looking at the nature of the business carried on. And 22.5 provides, in effect, that assuming you meet the other requirements of here, Article 11, and you are carrying on a business, and that business is of the right sort, and the interest that is received by you is derived from, connected with that business, then you are still entitled to rely upon the treaty. And this is a familiar exercise in the model treaty, and indeed in many of the UK's tax treaties, of what is called limiting the benefits. It's a limitation of benefits clause. And it has two main features here. The first limitation of benefit is in 22.2 by the status of the person. And then the second limitation of benefit is in 22.5 by reference to the nature of the business. Now, looking at 22.5 a little more carefully, it excludes here UK residents in receipt of inter alia interest from Japan, where that UK resident does not carry on the business. It also excludes those who have an investment business on their own account, but who are not a bank, an insurer, or a securities dealer. You are required to test whether the particular person in receipt of here the interest has a business at all, and then if it does have a business, is it one of making or managing investments, and is it doing so on its own account or on account of others, and is it a bank, an insurer, or a securities dealer? Now, if you've got a non-investment business, your business is not making or managing investments, I am going to say, in a little while, you are a trader. Equally, if you have a business that is making or managing investments, but you're doing so on behalf of others, to a UK tax lawyer, it is highly likely that you are also a trader, because you are providing investment management services in return for a fee. And then the third category is you are making or managing investments. You do so on your own account, but you are a bank, an insurer, or a securities dealer. In those circumstances, for reasons we'll see in a moment, you are a trader. So 22.5 is designed to draw a distinction between those that carry on what one can think of as active trades, active businesses, but it excludes those who have no business or those who carry on a passive investment business. So it has nothing to do with resident or non-resident. It has nothing to do with whether your business can be run by computer or not. It has nothing to do whether your business can be run remotely. And it has nothing to do with the nature of what it is that you buy and sell, whether spoons or fine art. It simply requires one to determine whether there's a business at all, and then secondly, the nature or type of that business. As my Lord Justice Popplewell put to my learned friend yesterday, this provision has to work when you're dealing with dividend income, which is Article 10, and interest income, Article 11, and royalty income, Article 12, and indeed other income, Article 21. Now, as we'll see in a moment, if you hold what might colloquially be referred to as an investment, a share, you might receive dividend income. If you hold an investment that's a debt instrument, you may well receive interest. If you receive royalties, the Lord gave the example of the back catalogue, with respect to absolutely on the money as an example, you receive royalty income. Article 12 extends to all forms of intellectual property, so it's royalties for anything. So if you receive royalties, you might be receiving royalties as an investor, but equally there are people who deal in intellectual property and deal in royalties, and so what you receive as royalty income might be trading income. So that explains why this rule applies for Articles 10, 11 and 12. It also applies for other income in Article 21. Thinking last night of a good example of that which might fall within Article 21, that might be trade or might be investment, the best I can think of is chattel leasing. So if you're leasing cars, or ships, or storage containers, aircraft, those are circumstances in which it might be a single transaction that the law would regard as an investment transaction. If I'm Avis, I'm renting cars around Europe on a week-by-week basis, that's trading income. So Article 21 is there as the sweep-up, but it's a sweep-up that also envisages that the income you receive might be investment income and it might be trading income. Last reference is Article 13, 22.5 applies for capital gains tax purposes. It is logically harder to see why you need 22.5 in the case of capital gains tax. Now, I can't speak, for obvious reasons, to Japanese tax law, but there are circumstances in UK tax law where it makes a difference. So there are different things you can do with losses to be set against chargeable gains, depending on whether you're a trader or an investor. So I can conceive of a circumstance in which even for UK capital gains tax purposes, you need to know whether the receipt you receive by way of proceeds of a disposal of a capital asset is received as an investor. But that potted, admittedly rapid overview explains why there's a reference to each of the articles and would allow you to conclude about the proper interpretation of Article 22.5 in the context of the treaty as a whole. Now, Article 22.5 is not one of the standard articles found in the model treaty. It is an optional provision contracting states can agree. So here the UK and Japan had to agree it. They couldn't just adopt the model. And we can see that from the commentary on the 2005 OECD model treaty. And to save me coming back to this, can we just turn this up? And I appreciate you've seen some of it already. It's in the authorities bundle, volume tab 28. Beginning at 736. So 736 tells you this is the OECD commentary from 2005, and there is a long commentary on Article 1, beginning at 738. And this commentary on Article 1 discusses improper use of the convention. That begins at paragraph 7 on page 741. My note records you were shown this by Mr. Thompson. So I think you've seen 7, 7.1, I think he mentioned 8, and then 9. But at some point, can I invite you to read all of 9, so 9 main paragraph and then 9.1 through to the end of 9.6. And this is discussing abuse of the treaty, but to save me coming back to it, can I invite you to note at 9.5 on 743, it should not be lightly assumed that a taxpayer is entering into the type of abusive transactions referred to above. A guiding principle is the benefits of double taxation convention should not be available where a main purpose for entering into certain transactions or arrangements was to secure a more favourable tax position, and obtaining that more favourable tax treatment in those circumstances would be contrary to the object and purpose of the relevant provisions. That's a ground 4 point, so not lightly assumed, and what you're looking for is the seeking of a tax advantage that is contrary to the object and purpose of the provision. At some stage, please do look carefully at 9.1 through to 9.6, but then turning on at page 744, there's a heading Conduit Companies. Again, a point I want to come back to in the context of ground 4. But can I invite you at some stage to read from paragraph 13 down to 19, but then picking it up for present purposes at paragraph 20. This records that the preceding paragraphs identify different approaches to deal with conduit situations. And then 2 lines down, states wishing to address the issue in a comprehensive way may want to include the following example of detailed limitation of benefits provisions aimed at preventing persons who are not resident of either contracting states from accessing the benefits of a convention. And then you have a possible clause starts at the top of 748, and Article 22.5 in the Japan Treaty is very closely modelled on 3a that begins at the foot of 748 and runs over to the top of 749. So the provision we're concerned with is It's not a standard part of the model treaty, but is an optional extra that is blessed by the OECD for contracting states to agree if they see fit. Now, I've shown you R22.5, which in effect seeks to identify those not carrying on a business at all. But if you are carrying on a business, there's then a further subdivision between those who are not carrying on a business of making or managing investments, those who are making or managing investments not on their own account, but on behalf of others, and then the third category is those who are making or managing investments, but doing so as a bank, an insurer, or a securities dealer. So recalling that any term not defined in the treaty itself is to be the subject of domestic tax law, the phrase we're interested in here is making or managing investments. And that is not defined. One does look to domestic tax law. So testing that, while not universally true, most companies will carry on a business. There might be isolated examples. If I set up a £10 company and the £10 sits on deposit and I do nothing else with it and I earn 0.03 pence a year, that might not be said to be a business. So, can't say universally that all companies carry on business. Most will. If there is a business, then UK tax law, well, I should go back one step. The decision of this court in GE Financial, Her Ladyship's judgment, Authorities Bundle, tab 26, Her Ladyship at paragraphs 127 to 136, pages 695 to 696, discuss what is meant by business. Her Ladyship says it's wider than trade, and there is some useful case law, but that case law can be encapsulated in this way. It's some kind of commercial activity, broader than a trade, but perhaps not extending to isolated acts. Now that's my paraphrase, not Her Ladyship's, but that's what you'll find in her paragraph 127 through to 136. I don't think we need to turn it up because it's not said here that FWC doesn't have a business. So if you've got a business, what then is meant by making or managing investments? And here we need to turn up the decision of Mr. Justice Lightman in the case of Cook, which is in the Authorities Bundle, tab 10, at page 190. This concerned a housing association. So it's set up as an industrial and providence society, Medway Housing Society Limited, and it incurred management expenses, i.e. the expenses of running the housing association, and the question was it entitled to deduct those expenses from its income? And that in turn depended on whether it was an investment company, where the relevant UK statute required it to be wholly or mainly in making investments. So what his lordship had to consider was what is meant by this notion of making or managing investments. So that's set out at slightly greater length in the head note.
You elided that making investments with making and managing investments. Is the and managing part of this statute?
Can I just, I was going to turn up the particular statute. It's at the top of bundle page 198, where it's section 130 of the ICTA 1988, which talks in terms of wholly or mainly in the making of investments. And what his lordship says, having set out letter A on that page 198, he explains the tax law significance of the dispute at letter B, and then he says at letter C it's clear and common ground that the word making includes holding. And then the issue, 3 lines down, the issue is whether the society's business consists wholly or mainly in the making of investments. And then can I just invite you to read, rather than me read it out, the paragraph at letter D that begins the term investment means. Over the page at bundle page 199, he has a heading, the authorities, and he looks at 3 English and 2 Irish authorities, which he thought were of significance. I don't propose to take you to those for present purposes. But picking it up at the foot of bundle page 200, 3 lines up, he says, the authorities, it seems to me, amply justify and support the conclusion which I have reached on principle. Can I invite you to read from the last 3 lines of bundle page 200 down to little b on page 101.
Incidental or the very business.
And just to note, letter little a on bundle page 201, it's relevant to have regard to the actual activities, but you only get a partial and incomplete picture if you don't look back at the past history or future plans. You've got to look at it in the wider realm. So that's the leading authority in the UK on what is meant by investment business. The other case that we need to turn up is nuclear electric, which is 1 tab back at tab 9 in the bundle page 183. And it's this case that explains the special status of banks and insurers. I shall explain by extension securities dealers. Before we come to the authority itself, if you're a bank, think of the most ordinary retail banking activity. You take in customer deposits. Those deposits are liabilities of the bank. The bank must hold capital, indeed now regulatory capital, to meet those liabilities. And it can hold assets to meet those liabilities in the form of cash or shares or securities. So as a bank, you are likely to be in receipt of dividends and interest on the assets you hold to meet your liabilities to retail customers. The question a long time ago was, is that part of your trading income? And the courts say yes, because holding those assets to support your retail deposits is an integral part of your banking trade. Second category, insurers. you're carrying on an underwriting trade, you've got premiums of 100, and you make payments out in a year of 98, you're in Mr. McCorber's world of happiness because you've made an underwriting profit of 2, but you also invest the premiums you've received to generate a return to cater for the possibility that you make an underwriting loss. And obviously that investment return in a bad year might make the difference between solvency and no solvency. So as an insurer, you necessarily hold what otherwise are seen as investments in order to support your contractual obligations to the people who hold your policies. And as far back as the early 1900s, in a case called Liverpool and London Globe Insurance and Bennett, the debate was, if an insurer receives dividends and interest, is that trading income? Answer, yes, because holding those investments to meet your liabilities to policyholders is integral to the trade. Indeed, in bad years, it makes the difference between solvency and insolvency. Third category, you're a securities dealer. Not uncommon that you will buy and sell dividends, say, over the dividend date. You buy come and sell X. When you receive the dividend on the dividend date, is that trading income or is it investment income? So what the cases say is, well, if you're a securities dealer, it's part of your trading income. So you might buy a security come dividend at 100, receive a dividend of 2, and sell the security after the dividend date for 99. So just looking at buying and selling, you've made a loss. Factoring in the dividend, you've made a profit of 1. What the cases say is that's a trading profit, because the receipt of the dividend by a securities dealer is part of your trading receipts, and it's a component of your trading profit. And that's why those 3 categories of business are given separate treatment in the treaty, because it is recognised that they hold what might colloquially be seen as investments, but they are held as an integral part of the respective trades. That's explained by the House of Lords in nuclear electric. What happened in nuclear electric is nuclear electric PLC were generating electricity through nuclear power, but they had significant long-term decommissioning obligations. So they sought to set aside a sinking fund that would be designed to meet those liabilities. And the debate was whether the return on that sinking fund is part of their trading income or not. What Mr. Aronson for the taxpayer was saying is, well, once you've accepted the principle, as the case law had for nearly 100 years in the case of banks and insurers and securities dealers, it ought to extend to nuclear electric. And the House of Lords said no. So it's in the bundle at 183. You'll see the head note, foot of the head note at 183. They refer to that very old case of Liverpool and London and Globe and Bennett in 1913, the House of Lords, and a more recentish case in 1974 of Bankline. I had a very minor speaking role, as you'll see at the non-speaking role at 184. But it's 189 in the judgment of Lord Jauncey. To note 186 at letter E, he poses the question, when does investment income amount to a trading receipt? That's 186 bundle page letter E. And then he cites from Liverpool and London and Globe. And then he answers this at 189 in letters B and D by saying, no, nuclear electric cannot bring itself within the special treatment of banks and insurers because in those instances they are holding investments to meet current liabilities. So in their case, the holding of the investments is an integral part of their trade. In Nuclear Electric's case, it was a consequence of their trade, because they had an obligation to meet the decommissioning liabilities, but it wasn't an integral part of their trade. So Nuclear Electric exemplifies the special treatment in UK tax law of banks and insurers. Doesn't specifically address securities traders, I accept, but the principle is accepted. And we also know, for what it's worth, because the judge cites to this in judgment paragraph 256, that the position is the same in Japan. Now, Mr. Thompson faintly suggested that one couldn't place much reliance on that because that was an example of using foreign tax practice as an aid to interpretation, and we're not doing that. We're simply pointing to the fact that there is common treatment in Japan to explain that because the contracting states have got similar tax regimes, that's why, no doubt, they could agree Article 22.5. Makes perfect sense in UK tax law and, as we understand it, in Japanese tax law. Now, in a sense, all of this should be common ground. What Mr. Thompson said on behalf of VietJet, though, he said three things. Firstly, he said, well, the activity of trade and the activity of making or managing investments are not mutually exclusive. Secondly, he said, well, a company can do both of those things at the same time. And thirdly, he said, FWC had a business of making or managing investments, even if it was carrying on a trade. Just for your note, those propositions can be found in the transcript for day 2, pages 67 to 68, and pages 81 to 82. Now, taking them out of turn, his second proposition, that companies can do both, is right. Best example of that is a holding company of a group which holds shares in one or more subsidiaries, and that is an investment activity, but it also might itself carry on a trade. So the court won't be surprised to learn that there are some large groups where there's a trade not only in the subsidiaries but also in the parent holding company. Now, if the parent holding company carries on a trade of its own, then it is doing both things. It has an investment business and it has a trading business. And they are taxed separately. And they're taxed separately because it has two different activities. So his second proposition is right. His first proposition, that the activity of trade and the activity of making or managing investments are not mutually exclusive, is wrong. Indeed, it's tax law heresy. For UK tax purposes, an activity is a trade or it's an investment, but the same activity cannot be both. If its true nature is one, then it is not the other. Specifically, a business that is a trade is not a business of making or managing investments. And a conclusion to the contrary by this court would overturn 160 years of tax law. I learnt a long time ago never to tell the Court of Appeal it can't do something. You may well be met by the retort, just watch us. but you really can't do that. There is a fundamental divide upon which the whole UK tax code operates, which is that you are either a trade or you're an investment.
You can have an investment business.
You can do both at the same time.
Yeah.
So my holding company is the perfect example, but the same activity can't be both. So Malone Friend's third proposition is also not true. If an activity is a business that is trading in nature, then that activity cannot also be an investment activity. Mixing my metaphors, the cat is dead or alive. It is not both dead and alive.
Are you going to take it to something which tells us that as an authority in clear terms? Because I think so far the authorities you've shown us don't really say that.
Well, your Lordship is one proposition ahead of me, as ever. I was lost in admiration for my own friend Thompson's submission that there's no case law that says that he's wrong. There's not a single case that says that he's right. So I looked last night, can I find an authority for what I regard as an absolutely fundamentally basic proposition? The answer is that once you have determined the true nature of a business as being a trading business, then it is not an activity of making or managing investments, or vice versa. And indeed, nuclear electric would have been argued differently, and almost certainly reasoned differently, if my learned friend were right. The debate in the House of Lords in nuclear electric was, well, if you receive what looks like investment income, can that be treated as trading income? Well, if you could have both activities one at the same time, where the activity is the same, then the debate in nuclear electric would not have arisen. Now, turning to the judgment below, the judge concluded that FWC had a business. That's at his paragraph 253. No appeal from that conclusion. So the relevant question is, what type of business? And here the focus had to be on FWC, Fitzwalter Capital Financial Trading Limited, not on FWA, the respondent in this case, or on Fitzwalter, or Fitzwalter Capital more generally. And in our submission, VietJet's case on this point has always been inconsistent as to which entity had to satisfy Article 22, subparagraph 5. And there is focus in the cross-examination of Mr. Weinstock, and in VietJet's submissions before the judge, and in the skeleton in this appeal, on the wrong entity. What you've got to bear in mind is it's this entity, FWC. Now, of course, it is true that the fund here, a hedge fund, is typically an investment activity. The court will be alive to this, but hedge fund is typically a partnership, often formed in places like the Cayman Islands, treated for UK tax purposes as being an investment business in most cases. The manager of the fund provides advice and management services in return for fees, and so it's carrying on a trade. It's a services for fees trade. But FWC here is neither the manager nor the fund. And we know that FWC is not a bank or an insurer or a securities dealer, and we know it did act for its own account and not for others. But that's not yet an answer to Article 22.5, because we have to determine whether the activities of FWC are the making or managing investment business, in which case there's no access to Article 11.1, or a non-investment business, in which case there is access to Article 11.1. So in our submission, deciding if FWC carried on a trade, the trade being the paradigm example of a non-investment business, was a legitimate analytical course for the judge to take in the circumstances of Article 22.5. And we also say, for reasons I'll develop in just a second, that the judge was entitled to decide that FWC carried on a trade, and thus it did not have the business of making or managing investments. And that's the judge at his paragraph 265. The judge's conclusion is that the nature of the activities that he had found, i.e. trade, precluded it from being an investment business. And we say that's right. Now, Mr. Thompson adverted to this very briefly yesterday, but again, the court may well have this in mind. Whether a particular activity is capable of being a trade is a question of law. And that appears from the decisions of this court in the cases of Eclipse and Samarkand. Because I don't understand this to be challenged, I'm not sure we need to turn them up, but Eclipse is in the authorities bundle tab 15 at page 362, and the relevant paragraphs are to 112 to 117. That's bundle pages 382 to 383. And Samarkand is at tab 18, page 456, and the relevant paragraphs are at 59 to 60 at page 476. So, two-part test for are you carrying on a trade? Is what you do capable of being a trade? And that's a question of law. If it is capable of being a trade, then whether or not it is a trade is a question of fact. So what the judge did in the present case was to determine that what FWC did was capable as a matter of law of being a trade. Just pausing there, what FWC did was to acquire loans in relation to these 4 aircraft between the 8th of October and the 29th of October 2021. Judgment paragraphs 51 to 52. It had instructed an agent to run a sales process for the aircraft. That's judgment paragraph 50. It took on the security trustee and agent roles in early November, judgment paragraph 55. And then it sold the security trustee's rights on the 8th and 9th of November, judgment paragraph 56. We also know that it acquired a 5th loan at that time and acquired others. We know that it acquired others from the evidence that Mr. Weinstock gave. Just give the reference. It's supplementary bundle, page 42, and his evidence is at internal pages 37 to 38. So he mentions a 5th loan and says that there were others. It turns out there were 3 others, so there were 8 in total. But the 5th loan didn't mature until early 2023. If you bothered to turn it up, I'm not sure we need to. That appears on the balance sheet of the first year's accounts. The accounts are in the bundle for a 15-month long first period, as at 31st of December 2022. And the 4 loans that we're concerned with have been and gone, they're in and out. The 5th loan is still on the balance sheet, but it's impaired as at December 2022. And that's in the supplementary bundle, tab 21. And you need to read pages 1444 through to note 12 on page 1448. So what FWC was doing was buying rights, happening to be in relation to debt instruments, so as to access the collateral. It was reorganising and rearranging the position as best it could to prioritise its own interests, and then realising value from those interests within a short space of time with a view to making a profit. It's like somebody who buys debt instruments at 15 cents on the dollar in the hope that they can sell them at 20 cents on the dollar. And that is capable of being a trade. Indeed, in nearly all cases, it will be a trade.
So is the touchstone for trade as opposed to investments in a simple, almost one-off transaction like this, whether you've acquired the asset for the purposes of selling it, or whether you've acquired it for the purposes of holding it?
In effect, yes. Now, there are other factors that you might look at, which is the length of time over which you hold and the clarity of your intention at acquisition. But you also need to see whether you do work on the asset in the intervening period so as to improve the asset or increase the value. And that...
Sorry, if you keep it and work on it for the purpose of improving value, that's part of trade, isn't it? That's a badge of trade.
It's a badge of trade.
Yes.
But I might buy something as a long-term investment. Like my Lord's example, I'm my own friends of, I might buy a flat in Tokyo. Well, I might buy a flat in Tokyo intending to keep it 10 years and I'll put a new bathroom in. My putting a new bathroom in doesn't make it a trade. But if I buy a flat in Tokyo intending to realise it as soon as I can, and I refurbish it to improve the value of it, and I turn it over within 6 months, that in law is capable of being a trade and highly likely is a trade.
And so authorities, there isn't an authority, as it were, for the very obvious proposition that trade and investment are mutually exclusive, as I understand it.
Well, I haven't found one that says that in terms. They all assume that to be true.
Yeah. The distinction between investment and trade must be recognised in the tax legislation, however.
It is.
But I don't think we've been shown, have we, where that exists as different concepts.
I contemplated walking in this morning with a copy of the yellow books and waving them at the court because they all rest on this key distinction, but they now like this, and we have neither the time and I didn't have the arm muscle to carry them. But the whole of the UK tax code proceeds on that distinction.
And as to what the legal test is, which is the legal point for distinguishing the two, I think Morton and Marson is identified somewhere in the judgment. That's an example.
It's what the Vice Chancellor then, Lord Justice Brown Wilkinson did was list factors there, and in Eclipse and Samarkand it is said, well, they're useful and interesting, but it's not a tick box exercise. So Marson and Morton lists the factors that my Lord has put to them.
They were badges.
They are badges. They are indicative and useful depending on the facts of a given case. But what the judge concludes here, if one turns up his 265, third line down, as Mr. Weinstock explained, and on which he was not challenged, FWA did not buy loans in order to obtain a return on the loans themselves, but rather to gain an upside from taking ownership of the underlying collateral. Furthermore, he went on to confirm that FWC generally tries actively to realise its position in the financial assets that it acquires and does not look to hold them to term. That indeed is consistent with what happened in the present case, enforcing the security and disposing of the value within the loans through the sale of the claims under the leasing arrangements and the separate sales of the aircraft. So there was there an intention to buy with a view to realising and to do so within a short space of time. That is capable of being a trade. The judge decides, as a matter of fact, it is a trade. So it is not said, I think, that the judge made an error of law in deciding it was capable of being a trade. But equally, it's not said a Bairstow type error in finding as a fact that it is a trade. Now, no one likes a pleading point, but there is an Edwards and Bairstow challenge on ground 4 in the grounds of appeal. There isn't on ground 3. Just for your note, that's core bundle, tab 1, page 16. So the case against us, as we understand it, it's not foreshadowed in Malone and Friends' skeleton argument, is not that he was wrong to decide that it was a trade, but that that doesn't matter. So there appears to be no challenge made to his conclusion as a matter of fact that this was a trade. It is said somehow that that doesn't preclude a conclusion that it is the same activity is also making or managing investments. And I say that's tax law heresy and impossible. But given that it's not said against us that this is not a trade, as a matter of fact, I'm not sure I need to take the court to the evidence that was before the judge. Because he's found as a fact it was a trade.
Can I just ask you about the tax law heresy? As you say, you haven't found any authority which says in terms that the two are mutually exclusive, but your submission, as I understand it, is that that is the underlying premise, which one can see in a number of other decisions.
Yes.
What are those other decisions where that it's clear that that must be the underlying premise? You've mentioned nuclear electric. Others?
There must be hundreds that look at the ambit of both trade and investment, where the premise upon which the court addresses the arguments of the parties is that a given activity is either apple or orange, but it can't at the same time be both. I can find, Your Lordship, a list of authorities where that is assumed to be true.
Perhaps your best 2 or 3 of high authority in this court or the House of Lords or Supreme Court.
If
it really is as heretical as you say, that ought to be fairly straightforward.
Let me do that, my Lord, and I'll do it either over the short adjournment or at least during the course of today. But unless the court tells me otherwise, given that, as we understand it, there's no challenge to the conclusion that it is a trade, I'm not sure you need to see the evidence that the judge addressed in arriving at his conclusion in paragraph 265. Because that's not said to be wrong in its terms, it's just said to be not enough somehow. On that basis, we would invite you to conclude that ground 3, the appeal, should be rejected. And subject to that little bit of homework my Lord has indicated would be useful, unless there's anything else on ground 3, I'll say no more about it.
Thank you.
So ground 4, again, one needs to have in mind, I'm not going to go back to it, the interpretation of the treaties. So one needs to go back to Royal Bank of Canada, Anson, Fowler, GE Financial. I've given you the references. You've also seen the purpose of Article 11 being to allocate taxing rights, so that's familiar. You've now seen Article 11.7, and Article 11.7 designed to stop what's colloquially called treaty shopping, but it only applies where there is a main purpose of securing a favourable tax position under the article. So in 11.7, we're looking at a favourable tax position under Article 11. And it has to be a main purpose of securing a favourable tax position under the article by the creation or assignment of the debt claim. And we say, properly understood, what Article 11.7 is doing is directing you to find an offending main purpose of seeking to secure a tax advantage that is contrary to the object and purpose of Article 11 itself. And that can be seen in the OECD materials that I took you to in the 2005 commentary that are in the Authorities Bundle, tab 28, from page 736 onwards. And in particular here, looking at pages 747 and 752. So it's that commentary that makes the point that you're looking for a tax advantage contrary to the purpose of the treaty. That proposition also appears in a decision of the upper tribunal in a case called Burlington. And that's in the Authorities Bundle, tab 25. Factually a little complicated, but it's another Lehman's related dispute where the Lehman's estate were going to make a payment out which would bring with it interest, and the original holder of that claim would have suffered withholding tax on the payment of the interest. So just assume, as a simple example, if the interest were 100 and the withholding tax was 20, the original holder would only ever get 80. So what the original holder did was to sell that right to the interest to Burlington, Burlington being based in Ireland. And Burlington had a better treaty position so that Burlington would get more than 80 of the 100 of interest. And because Burlington was in a better position than the original holder, it allowed the parties to have a fight about the price at which that interest claim would be bought and sold. And so the revenues challenge when Burlington had bought the debt claim was under the UK-Irish Treaty, Article 12 there, but materially identical to our Article 11. UK Revenue said, well, you, Burlington, or the seller, have a main purpose of securing the benefit of the Irish Treaty on the assignment of the debt claim. So the upper tribunal in Burlington had to address this notion of what does their Article 12 here, Article 11.7 mean. So that's a very short paraphrase of the head note. Can I invite you to turn up paragraph 7? So this is Mr Justice Richards and Judge Scott. You'll see that at the head of 640. And at paragraph 7, the foot of 640, you'll see the application of Article 12, which is the equivalent interest provision, was subject to an anti-abuse measure, 12.5. And 12.5 is in materially identical terms here. And paragraph 9 over the page records the fact that the first tier had concluded that the assignment of the debt claim to Burlington did not engage Article 12.5, so the revenue were appealing. And then paragraph 10 sets out the relevant provisions, and you'll see between letters G and H on page 641 of the bundle, 12.5 of the Irish treaty, materially identical to 11.7 of this treaty. And then over the page, bundle page 642, there is paragraph 13 in the upper tribunal that begins before the FTT. There was some debate as to the proper approach to the construction of Article 12.5. However, the following conclusions of the FTT are now common ground. And can I invite you to read, rather than me read out, read paragraph 13 and then also paragraph 14. So Article 13 makes the point that we're looking at main purpose in the sense of subjective intention, and main means, as the court had indicated in travel documents, not just something more than trivial, connotation of importance. And then 14 records that the two issues in dispute were 14.1, does this provision only apply if you've got artificial arrangements? The upper tribunal are going to say no to that. And then the second point, peculiar to the facts of that case, is can the seller have a main purpose if it knows the treaty status of the buyer? And if it can, what happens if it doesn't know the treaty status of the buyer? Now, I should say now that this case is coming to this court. So Lady Justice Falk gave permission about 6 weeks ago at an oral hearing. I don't think it's yet been listed, but it will be heard sometime, I imagine, in the autumn or early next year. But my understanding is that what's in issue is not the artificiality point, because that's now accepted, nor is the purpose of the seller in issue. The sole issue on which she's granted permission to appeal relates to the purpose of the buyer. And of course, the facts in that case are obviously a long way from the facts of ours. You just need to know it is coming to this court. So then turning on in the report itself, can I wait to turn to paragraph 43? Bundle page 649, heading ground 1, meaning of Article 12.5. So 43 is a reminder that you need to look at it in context by reference to the Vienna Convention on the Law of Treaties and interpret in good faith in accordance with the object and purpose of the treaty. 44, you can look at OECD and UN materials. And then 45, unlike the FTT, we start our analysis by considering the object and purpose of the treaty having regard to the relevant OECD and other materials. So they recognise there that in judging the application of 12.5 in that case, 11.7 in our case, you are required to look at the object and purpose of the provision. So at some stage it would be helpful if you could read down to 45, and then there's a longer passage again, which I'm not going to read out, but it begins at paragraph 47 on bundle page 650. and I'm in the court's hands in a sense whether you read this now or at some later junction, but it's 47 through down to 61 on page 653. Partly concerned with the facts of that case, but more significantly for present purposes, making the point that when you're looking for taking advantage of Article 11 by the creation or assignment of a debt claim, you're looking for a tax advantage that is contrary to the object and purpose of Article 11.
Despite the fact that I hate homework, I think it's better if we do that in our own time, as long as you've made the points that we need to take.
Yes, well, I've made the two key points. You have them in the transcript. So when it is said against us, as my friend Lord Wolfson did yesterday, that what we're attempting to do in the present appeal is apply some kind of gloss on the statutory test, or as he said, I think yesterday, to insert some words, taking advantage in the sense of producing a tax result that's contrary to the purpose and object of the provision. That is neither a gloss nor an insertion of words, that's purposive interpretation. That's what the upper tribunal in Burlington says is the right approach, and we respectfully agree. So one needs to bear in mind it's the purpose of securing a more favourable tax position from the creation or assignment of the debt, not, for example, from the incorporation of an entity. And we know from the OECD materials that I showed you briefly, perhaps 40 minutes ago, that this is not to be lightly assumed. Because by applying this anti-abuse rule, you are turning off the treaty, that treaty being designed to avoid double taxation. So yes, in appropriate cases, you can turn off the benefits of Article 11, but that should not be lightly assumed. So what's 11.7 aimed at? The paradigm case is an entity in a treaty favourable jurisdiction that is interposed between lender and borrower to allow for the payment of interest gross or at a lower rate of local withholding tax, sometimes referred to as a conduit company. So you've got Party A in jurisdiction A has a loan deal with Party C in jurisdiction C, but there's no suitable treaty between those two jurisdictions. So what Party A might do in such a case is to interpose Party B in jurisdiction B, where there is a good treaty between jurisdictions B and C, and indeed between A and B, as a means of taking advantage of payment gross. But it can be said in such a circumstance that by the interposition of that conduit company and the assignment of the debt claim by A to B, you are producing a result that's contrary to the object and purpose of the provision. That's the paradigm case. Now, we quite accept that the terms of Article 11.7 are not limited to such paradigm cases. They can arise in other circumstances. But even in those other circumstances, you are looking for a purpose of securing a more favourable tax position. And here the case against us has to be that it's the creation or assignment of the debt claim with a view to taking advantage of Article 11 for the payment of interest gross without withholding tax in Japan. So, a number of points to make here. My own friend said in submissions yesterday, in fact, not yesterday, day one, Wednesday, that there was no indication that any defaults had occurred when the loans were assigned. I'm wary at this point of treading on Mr. Smith's manicured lawn, but that's not quite right. While there was no capital E event, capital D default under the loan, because of the limited recourse nature of that loan, the loans were in default at the point FWC took the assignments, because VietJet had fallen into arrears on the rental payments earlier in 2021, and that lease default caused the acceleration of the loans. So the judge found as a fact that there was no prospect at the time the loans were assigned of interest being paid. Now, as my lord observed yesterday, it is the case that default interest was payable. But it could not be suggested, and in any event has not been suggested, that the prospect of getting default interest was a main purpose for taking assignment of the loans. There's no evidence to that effect.
Well, is that fact dependent on what the value of the aircraft was and the extent to which there might have to be an accounting to the borrower? The significance of the default interest in relation to FWC's activity in taking the assignment to exercise the security rights is that it affected the extent to which it could keep those proceeds, because it was only a security interest. I can quite see that if the numbers were such that actually the default interest wasn't going to make a difference to whether it was going to account, you could say it can't have been any purpose to take advantage of the double tax treaty. But if, on the other hand, there was a prospect that the exercise that FWC was going to undertake would produce a different amount of money for it by operation of the default loan interest, then can one say that at least, take it in stages, a purpose of taking the assignment was to take advantage of the favourable double tax treaty?
I accept from your lordship that, of course, it's theoretically possible in those circumstances that it could be a purpose. Yes. And if the amount is big enough, your lordship may well say to me, well, is it theoretically possible that that could be a main purpose? I would accept it. But it was not contended below, nor is there any evidence nor any finding of fact, that the prospect of default interest was sufficiently significant that it constituted either a purpose or indeed a main purpose. The point just didn't arise, never brought.
And the way the case is put against you is, you look at why FWC was incorporated, or its place of incorporation as the vehicle that's used, and that was to take advantage simply because take advantage means doesn't have to be abusive, and it had that advantage.
Can I come to that in stages?
Yes.
But the point, the judge concludes there's no prospect of loan interest.
Being actually paid.
Yes. And he finds that.
Yes.
Now, your lordship is putting to me that that may not be enough. So let me go on and deal with it. What Lord Wolfen said yesterday is, well, if that's right, do you somehow then fail to be a qualifying lender under clause 9.1? Because if there's no prospect of interest being paid, then you can't meet clause 9.1 that talks about an entitlement to interest payable. My answer is no, those two propositions are different. The fact that there may be no prospect of interest being paid does not affect my entitlement to interest payable. And secondly, he said, well, does that mean you can't satisfy the requirements of the treaty because you're not a person who can benefit from Article 11 and receive interest gross? The answer is no. Whether or not interest is going to be paid, if I have the right status under the treaty, I can benefit from the treaty and receive such interest as is paid gross. So what my friend is there doing is confusing the qualification as a qualifying lender as a matter of status with the prospect of whether interest was going to be payable at the time of the assignment of the loans, which goes to purpose. And they are different questions. So we say with respect that's a bad point. But even if there was a prospect of interest being paid, and let's assume we include default interest, that interest would be taxable in the hands of FWC in the UK. There is no onward payment to any other person. FWC is not a conduit company. It's not been interposed. So the paradigm case of Party B being interposed between A and C just isn't present here. So the point made by the judge is ultimately a good one. There can be no abuse of Article 11 of the treaty. If interest is payable, it is taxable in the hands of the person seeking to rely upon the treaty. So yes, you don't suffer Japanese withholding tax, but the consequence is, because you're a UK resident, is you pay UK corporation tax. And that gives effect to the purpose of Article 11. It's not a state of affairs that somehow negates or undermines the purpose of Article 11. It aligns perfectly with the object and purpose of Article 11 itself. So ultimately, we say the judge's conclusion is a good one. What Malone and friends say in their skeleton, and it was faintly expressed in Lord Wolf's oral submissions, is that FWC was incorporated with the main purpose of becoming a qualifying lender, achieving a particular contractual status so as thereby to take assignment of the loans without consent. And he says that, in effect, is taking advantage of Article 11. And we say there are 5 insuperable problems with that contention. First, Article 11.7 requires a purpose of securing a favourable tax position, and achieving a particular contractual status is not achieving a favourable tax position. That's not what Article 11.7 is aimed at, and that's clear, we say, from the OECD commentary. Second, to reiterate a point I made just a second ago, while there's no requirement of any artificiality in Article 11.7, so we accept Burlington and the upper tribunal, the purpose has to be to achieve something that is contrary to the object and purpose of Article 11. And here, that is not offended because the real recipient, FWC, being entitled to interest without local withholding tax, is exactly what these contracting states have agreed to. It's not something that negates or undermines Article 11. Third problem is what matters is the purpose of the creation, or here the assignment of the debt, and not the purpose of the incorporation of FWC. Malone friends are attempting to hit the wrong target. Their case throughout has always been that it was the incorporation of FWC that was the sin. But that's not the sin at which Article 11.7 is addressing. Fourthly, Article 11.7 requires the identification of a specific type of main purpose, and whether that is present is a question of fact. That's Court of Appeal decision in BlackRock and others. Here, the judge said there was no offending main purpose. That is a conclusion of the judge of fact. That's his paragraph 278. My learned friends' grounds of appeal here do make an Edwards and Bairstow point. They say that's not a conclusion that he could properly have arrived at. This court doesn't need to turn up an Edwards and Bairstow, it's in the bundle of authorities, tab 5. That's expressed by the House of Lords in terms of a decision that is perverse, or one which no reasonable tribunal could have arrived at. So we say on the evidence, the judge was clearly entitled to make that finding, and the very high hurdle that the learned friends must cross is nowhere near met. The judge here recorded his paragraph 2 that Fitzwalter Capital is a UK headquartered group. There was also evidence before the judge that the relevant people for these transactions were based in the UK. And Mr. Weinstock gave evidence in his statement and in cross-examination about the nature of FWC's business. And we know that FWC was a UK resident company. So there was clearly evidential material before the court on which the judge could find as a fact that there was no offending main purpose, and my learned friends come nowhere near crossing the Edwards and Bairstow hurdle to overturn that, nor have they seriously tried. Now, what VietJet did below was to invite the judge to draw adverse inferences from the absence of particular witnesses, and the judge refused to draw such inferences. Lord Orphan attempted yesterday to invite this court to draw those inferences. As the authorities make clear, authority in the bundle of FOB, tab 21, page 534, in particular paragraphs 41 to 42, which are bundle page 547, that exercise in drawing adverse inferences from the absence of a witness requires one to review all of the evidence, oral and documentary, to form a view about the significance of what is said to be missing and the cogency of that evidence to one side's case or another. That's classically an exercise for the trial judge. What paragraph 42 of FOB goes on to say is, my paraphrase, that is almost impossible to overturn on appeal because an appellate court simply cannot do that exercise in weighing the evidence that the judge heard. So you can't, with respect, we would say, accept my learned friend's invitation to draw the adverse inferences that the trial judge did not. My last point, fifthly, VietJet's case is, to reiterate, that as a matter of fact, FWC was incorporated with a main purpose of becoming a qualifying lender for the purposes of the relevant contractual terms, thereby to allow it to take assignment of the loans without consent. That's my learned friend's case, paragraph 63 in their skeleton, core bundle, page 39. Now, putting aside the other criticisms we make of this, testing the wrong thing by looking at incorporation, and in any event it's not sufficient to engage Article 11.7, these are simply not findings of fact that the judge made. So my learned friend was then driven to make a type of reasons challenge, contending that the judge had not expressed adequately his thinking in coming to the conclusion that he did. That was rather like Mr. Thompson's attack on the judge more generally. It was unwarranted. One needs to read all of the judgment, paragraphs 267 through to 278, and there is nothing in our submission wanting in that reasoning or ultimately in the conclusion that the judge arrived at. The reality is the judge formed a view about the main purpose question on the basis of the evidence that he heard. This court should not interfere in that evaluative exercise and certainly on the basis of an incomplete view and analysis of all of the evidence. So we would say, echoing the judgment in Lifestyle Equities, paragraphs 49 to 51, Authorities Bundle, tab 23, page 580, there is simply no basis here to make findings of fact as to main purpose, which the trial judge has not made. So on that basis, we would invite you to dismiss the appeal in relation to ground 4.
Thank you.
Now, there will be a degree of shuffling, so I'm the last warm-up act for Mr. Lissock. If you'll just give us 30 seconds.
Mr. Lissock.
My lady, my lords, literally last and legally least, ground 5. I have just 2 submissions to make. I shall make them, I hope, with the appropriate economy and subject to assisting the court with any other aspect which I fail to cover, I'll be done. The 2 broad submissions I make are these. First, that this court should decline jurisdiction to rule on this ground, it being obvious that the threshold relied upon by my learned friends in the case of W is not crossed in this case. Secondly, if you are against me on the threshold point, that the court should reject ground 5 as being utterly devoid of merit. I deal with the jurisdiction submission, if I can call it that for shorthand, first. There is, we submit, no jurisdiction to allow this court to entertain this ground at all, given how it is now premised. Ground 5 is brought on the contrived, and that is a generous way of putting it, basis. It runs as follows. Whilst the issue in the ground does not affect the nature of the judgment itself, same learned friends, paragraph 69 of their skeleton. They say they are entitled to appeal because they may be prejudiced in other proceedings by findings of fact in this judgment, and therefore justice requires this court step in to undo the harm that has been done to them. Secondly, they say in the same paragraph in their skeleton, this situation brings them within the shelter of the narrow exception recognised in W, Authorities, tab 17, page 422. That is to this effect, and you've looked at it already, and I'm mindful of that in making these submissions now. Where a court makes findings adverse to a party, or even a non-party, as in W, in violation of that person's rights, and that finding is so serious as to amount to a denial of a fair trial, and therefore the court itself would be in breach of the Human Rights Act, in infringing the party's rights under Article 6 or Article 8, or both, the Court of Appeal has jurisdiction to entertain an appeal by that non-party or party in order to ensure that there is a remedy for a said violation of Section 7 of the Human Rights Act. The proposition in W is, of course, with respect, undoubted. However, the learned friend goes on to suggest, in recognising the reality of the position put to him by the court in his submissions, that W would have to be extended in its reasoning for him to get within the shelter of its judgment. He says the extension required is but a modest one, going to page 128, lines 11 to 14. But with all respect to learned friends, forensic advocacy and skill, that is a dramatic understatement. May I invite you, please, to look at W one more time, and as I say, you'll find it at tab 17 in your authorities bundle. I do this only briefly to invite you to note, first of all, on page 423, for later reading, if you very kindly would, at the headnote, paragraph 2, which is a very good summary of what this case is about. And to come, please, to the last page of the report, page 455, paragraph 121, where the Court of Appeal's conclusion is stated in the judgment of Lord Justice McFarlane in clear terms, which I'd invite you just to remind yourself of by reading them to yourselves now, please. My lady, my lords, that being learned friend's position, can I state in 4 short reasons why we say he has no basis to invite this court to exercise that jurisdiction, extended or otherwise? First, unlike the position that we have in the W case, VietJet was not just a party, it was the party to these proceedings, with every opportunity to seek to challenge the evidence and legal arguments relied upon against it, the very opposite of the position in W. It is the violation of a person's human rights by procedural defects at first instance which triggers the Court of Appeal jurisdiction under W, not that a finding may prove to be inconvenient to a party in parallel or subsequent litigation. Our case was pleaded, articulated, and detailed, and there was no surprise in it. Happy as I am to take the court to the pleadings and to our summary, I think it might suffice if I just give you the references in case you wish to check the veracity of what I say later. So can I please invite your attention to note that the last iteration of our reply and defence to counterclaim contains at paragraph 29.2.5 the relevant conduct with which this application for this appeal is now concerned. For your reference is tab 14 in the core bundle, page 391 and following, through to 395, where we set out the allegation that the defendant, i.e. VietJet, has sought deliberately to interfere, etc., and then set out the detail, including the shareholder proceedings in Vietnam and the replacement shareholder proceedings in Vietnam and the breach of the Mr Justice Bryan's order. It is worth noting that VietJet has never contested the underlying facts that underpin the pleading therein set out. And in terms of notice of FWA's case, VietJet was obviously aware of the contempt application made against it on the basis of these very facts on the 31st of March 2023. The second source of our case, which I can give you the reference to as well, is in the supplementary bundle, beginning at page 1338 and going on to page 1341. to which I will take you briefly in my second submission, if I may, in a moment. But that is our written closing, of which complaint is made by my learned friend, although it came and went somewhat in his submissions, that the judge was either wrong or in some other way flawed in his approach, in his acceptance of it. Whether that's right or wrong, I don't know, it's still sustained as an argument against us. The fact is that VietJet knew precisely what our case was. It is therefore, we respectfully submit, simply not sustainable to submit as my learned friend did, that VietJet, and these are his words from the transcript, day 2, page 126, lines 7 to 10, that VietJet wasn't expecting, and oughtn't to have been taken to have expected, to find findings in the terms which the judge did find, based on what he had in front of him. Although my learned friend did appear to walk back from that, the absolutism of that position, whether walked back from or not, it is a wholly unsustainable proposition. They knew perfectly well what the case was. It was all laid out in the pleadings, it was laid out in our written closings, and it was before the judge and formed part of the material on which the judgment drew. The second of the four reasons why we say this first basis of our challenge to the jurisdiction is correct is this. The principle in W, which my learned friend seeks to invoke, does not permit of a situation which is self-engineered. Yet that is what we have here. It is only by reason of VietJet's procedural choices that it can claim, as my learned friend does in his skeleton argument, that this is a finding which it could not challenge. Paragraph 69, footnote 14. They have to say that because they recognize that it is an essential prerequisite to the complaint, when in fact VietJet could have appealed the refusal to grant relief from forfeiture to this court. It has not. It could at any point during the almost last 2 years have applied to strike out the contempt application. It has not. And the fact that it has done neither does not turn the proceedings before Mr Justice Picken into a violation of their rights that may or may not arise later, let alone a right to a fair trial, which entitles it to ask the Court of Appeal to intervene. Rather, it is a function of their own decisions. Thirdly, we respectfully invite the Court to note that it is entirely orthodox as a matter of case management and sequencing for contempt proceedings to be listed after the substantive proceedings out of which they arise, where there is a crossover of issues. A party cannot therefore be heard to complain, we submit with respect, of procedural unfairness when there is an adverse finding on such an issue in the substantive proceedings. And fourth and last point, my first one, two submissions, the last point is this. My learned friend had teased out of him by the court's inquiry in the course of his submissions that he is not saying that there is any unfairness, as it were, yet. He agreed with my Lord Justice Popplewell, day 2, page 130, lines 4 to 8, that there was no breach so far. What rather my learned friend said was there was potentially a problem if in fact matters are inappropriately used in the future, and that was his inchoate position or problem. But that avoids the obvious, which is the fairness of the contempt proceedings in which resides his inchoate problem for the future, which may or may not eventuate, will be managed and controlled by a judge. If there is an attempt, I don't know whether there will be or there won't be at this distance, some way off in the future in some as yet unlisted trial, for contempt, if there is an attempt to use material to which objection is taken, then the admissibility of that material in the contempt proceedings will be determined by the judge presiding over the contempt proceedings. Therefore, unlike the position in W, there is built into the system, baked in to my learned friend's own proposition of apparent unfairness, the remedy. That issues that he fears may or may not eventuate will be dealt with, if they do, in the appropriate place. My lady, my lords, those are our submissions on jurisdiction. Can I move to the merits, which will be shorter?
Okay,
Of course.
I should know the answer, but I don't. One often says, as if it's trite, that appeals are against orders, not decisions.
Yes.
Which are the provisions of the civil procedure rules which embody that? I don't expect you to have them at your fingertips, but perhaps someone could find them. Because if we're dealing with jurisdictional questions,
yes,
and it's said we have no jurisdiction, as opposed to we shouldn't exercise the jurisdiction.
understood.
Your submissions proceed from the basis, really, that if there is jurisdiction, it's not a W case and it's not the kind of case where it should be exercised.
Yes, I've used jurisdiction as shorthand, as,
yes.
I hope I said. And I'm sorry, I don't have the civil procedure rule to hand, but we'll provide it to you shortly.
I don't know if it would help, Mr. Lisser. In Re W, section 16.1 of the Senior Courts Act is cited as the basis for that, paragraph 46, page 436, my lord, of the authorities bundle. That's the start of the discussion in Re W.
Paragraph 46.
Yes, my lord, 436. I don't know if that's...
Thank you. But of course, as you know, and if I could just invite you to glance at this, perhaps, in Learned Friend's skeleton argument for this appeal, paragraph 69, on core bundle page 41, you will see footnote 14, and it's always interesting what finds its way into the text and what finds itself into the footnote, because I think Lord Wilson once observed to me in a different context. And if we look at footnote 14, VietJet recognises that appeals are normally brought against orders rather than specific findings in judgments. A finding may, however, be appealed where it is necessary to avoid a breach of Article 6 of the ECHR. So their approach is that a recognition of the generality, it doesn't answer my lord's question as to which is the rule, but it's interesting to see that's their approach, the recognition of that. So there's really no contest as to the unusual position in which we find ourselves at the least.
Yes. Well, as Mr. Thompson points out, the section 16 of the Senior Courts Act, which deals with jurisdiction, it's a jurisdiction to hear and determine appeals from any judgment or order.
Yes.
But it may be that there's some learning on what's meant by judgment in that context.
Yes. I think that without being
it may not be a matter for the rules, that's what I'm saying. I may have asked the wrong question.
But I was going to say, without being blasé, and we'll come back to some of the best of the list, whatever is meant by a judgment or a ruling, it certainly is what they're asking the court to look at here, which is the finding of fact, which they say leads then to the legal conclusion. It is the legal conclusion they seek to challenge on attribution under ground 5. But may I deal briefly with the merits point, and then I'll be done in probably 5 minutes, maybe a little longer. Ground 5, core bundle page 17, which you've looked at already, is a complaint that Mr Justice Picken allegedly attributed to VietJet the conduct of its shareholders, which is confirmed in Malone Friends submissions yesterday. Transcript J2, page 117, line 24 to 118, line 10. This is, I regret to submit, a straw man of an argument. It's not the case that was made at trial, and it's not the case that Mr Justice Picken accepted. Another friend complains that Mr Justice Picken relied too much on our closing submissions at trial. And so, as I indicated I might, may I invite you please just to look at those now, if you kindly will. It's supplementary bundle, page 1339, which is tab 18, and towards the end of our written submissions. Probably best to start, just for context, foot of page 1338, if you kindly would. Paragraph 279. Fourth line, or end of third line, it is this conduct by Madame Tao and Dr. Huang, which is attributable to VietJet. And then we set out over the succeeding sub-paragraphs, and I invite you please to particularly note 279 spot 4 to spot 5 on page 1339, where we put our attribution case on the basis that Madame Tao and Dr. Huang were respectively CEO and Vice Managing Directors of VietJet, and importantly, both were statutory legal representatives with statutory legal authority to represent VietJet in court proceedings under Vietnamese law, evidenced by reference to documents in the trial bundle, a point that was never contested. Furthermore, it's worth me respectfully reminding the court, and I'm sure it has this point already, that there was no dispute as to the principles of corporate attribution in the course of the trial, meaning it was not then and is not now, as I understand it, controversial between the parties that the conduct of individuals as senior within VietJet's corporate structure as these two were can be attributed to VietJet as a matter of law. At 279 sub 6 on the same page in the supplementary bundle, page 1339, we make clear that the relevance of the reference to them being shareholders is that Silver Star and the replacement shareholders brought the shareholder proceedings on the basis that the Civil Aviation Authority of Vietnam's deregistration decisions had prejudiced them as shareholders in VietJet. But the point made at 279 sub 6, which Mr Justice Picken accepted in the paragraph 377, which you have been good enough to look at more than once in the course of this appeal, but for your reference is core bundle, page 151 to 152, is that if Madame Tao and or Dr. Huang had brought the shareholder proceedings in their own names as shareholders of VietJet themselves, that would have been attributable to VietJet, but still on the basis that they were its statutory legal representatives. And in circumstances where Mr. Justice Picken found as a fact, unchallenged, that Madame Tao and Dr. Huang used Silver Star as a corporate cipher, these are the judge's words, for what VietJet or they themselves could not do directly. Judgment page, paragraph 377 again. What does VietJet hope to achieve through this element of their appeal? The only point of law which VietJet seeks to establish is that if an individual acts through a corporate vehicle rather than directly, that debars the court from attributing any relevance to the fact that it was the individual which procures the corporate action.
But is the premise right? Is it right to say that if they brought the shareholder proceedings in their own names as shareholders, that would necessarily have been attributable to VietJet without more? I mean, normally, the conduct of shareholders is not attributed if they're doing something in their capacity as shareholders.
Correct. I was coming to the crescendo which is that the status of shareholder is incidental to their position as office holder. It is not qua shareholder that the attribution route works. It is qua CEO and whatever the other title was that was held by the relevant individual at the time. The fact they have to also own shares, which is, as my lords and lady know very well, not in the slightest bit uncommon, is neither here nor there for purposes of attribution. The shareholder point applies as regards the status of Silver Star, and in the replacement shareholder proceedings, those claimants bringing their claim as shareholders of VietJet. Our point being that the shareholding status of the individuals is neither here nor there. It's their position as senior officers in law and fact that renders the route to attribution perfectly secure.
It's my fault. I'm not quite following, I'm afraid. Just stick for the moment with 279.6.
Yes.
If they'd brought the shareholder proceedings in their own names as shareholders, which I assume they were,
Yes, they were.
this conduct would have been attributable to VietJet. Why is that so?
Well, in the sense, the clause between the two commas is OTOs, because our case was that if Madam Town and Dr. Huang had bought the shareholder proceedings in their own names, this conduct would have been attributable to VietJet. The bit between the commas is, it's OTOs.
But that is mirrored and repeated at 377.
Yes.
The judge says, as such, if they had brought the shareholder proceedings in their own names as shareholders of VietJet, their conduct in doing so would be attributable.
Well, he had
to
picked up
VietJet.
on the language in our closing submissions, but it doesn't undermine the rightness of his conclusion that if they brought the proceedings in their own personal names, their conduct would have been attributable to VietJet, given their status and given the nature of the proceedings in Vietnam.
What right might they have had to bring proceedings in their own name?
Their right would have been as shareholders. In other words, they would have stood in the shoes, instead of it being through a corporate cipher, Silver Star, or the replacement shareholders, they would have sued in their own names and said, my rights as a shareholder under Vietnamese law are compromised by these wrong decisions, and therefore I wish to bring proceedings.
So if they'd done that, as indeed those words in between the commas are quite important then, as shareholders, they brought the proceedings, it's only the shareholders to bring those proceedings. Why is the mere fact they're also senior officers make that conduct of VietJet?
Well, there are two different strands in play. Strand one is, in what capacity would they have instituted the proceedings in Vietnam, instead of it being done through a corporate cipher as it was, as the judge found? Answer that my Lord Judge just gave, or we just had an exchange about. The second strand is that the conduct in so doing would have been attributable by reason of their office as legal representative of VietJet and as the two senior individuals within this large international organisation. So one concerns the status upon which the basis on which they bring the proceedings, the other concerns the basis for attribution.
So everything they do, qua shareholders, is also done qua or on behalf of VietJet.
No, don't go that far. No, but it depends upon, as my Lord knows so well, that the doctrine of attribution operates on the basis that a corporate can only be held liable under English law insofar as the actions of an individual who is guilty in inverted commas can be attributed to it, the doctrine of identification. So it depends upon the activity in question. Now here the activity in question was the bringing of shareholder proceedings. And the bringing of the shareholder proceedings was for the benefit of only one entity, and that's VietJet. And if it had been done in the direct name of the two individuals, the consequence would have been that it would have been a breach of the terms of Mr Justice Bryan's order.
But you say it was only in the interests of VietJet. If the premise is that a shareholder could properly bring these proceedings, let us assume a wholly unconnected shareholder brought these proceedings, and they would have status to do so qua shareholder.
Yes.
that must be because they would have a legitimate interest in the relief that they were seeking, qua shareholder, which one might imagine would be, although this is all presumably a matter of Vietnamese law,
Yes.
one would expect would be that the deregistration affects the value of my shareholding.
That would be the premise that one would think they would apply on, yes.
Now, if a shareholder has status to bring such an action for that reason, the fact that Madame Tao, let's say, did so, assume for the moment she'd done so in her own name because we're dealing with this in stages.
Yes.
Why should that be attributable to VietJet simply because she was the ultimate beneficial owner or the statutory representative, or that she had authority to do all sorts of things on behalf of VietJet? She wouldn't be doing that on behalf of VietJet, would she?
Well, it depends. It depends upon what the other facts are surrounding it. So that if you've got the circumstances that as the judge found in the complicated weave that he worked through of the factual premise that applied here with the sequencing and the issuing of the proceedings and then their being stayed and then them being abandoned and replaced by the new ones, and he regarded the whole thing as being orchestrated as part of a campaign, which was what our case was, as you know. He found on facts that are not challenged here that that was sufficient to allow him to reach the conclusion he did in 377 and elsewhere.
Well, I quite, forgive me, I quite understand you have a case that the judge was entitled to find as a matter of fact that this was orchestrated by them acting for VietJet.
Yes.
And maybe factual circumstances beyond what we're looking at here which justify that conclusion.
Yes.
Just taking it in stages, is 279.6 right, without more?
On the fact, no, I see the point that my Lord makes. If the proposition being put to me is, would it automatically follow that every single time there would be attribution? The answer is no.
So then we're going to need to focus on what the extra facts are.
Well, we need to focus upon the facts as found by the judge, given the limited grounds of the appeal that's now brought. And as far as that involves rolling in the other factual background, then yes.
Yes.
Because he states in the last sentence of 377, in so using Silver Star, they were acting for and on behalf of VietJet, to which their acts are manifestly attributable. And then he goes on to deal with all the sequence of events.
Yes, exactly.
So that seems to be something different from what he said earlier in paragraph 377.
Well, it evolves, because there were different tiers to the misconduct, as we labelled it, in the course of the case, as you know, my lady. And he dealt with them sequentially and in a way to which there is no criticism made of in the course of this appeal, I think, now. And the interesting thing is that the position that is struck by learned friends in the face of this judgment is an unacceptable submission, not only contrary to common sense in the way in which it seeks to get round the use of Silver Star, but it's contrary to authority. The very point made by Lord Sumption in Prest and Petrodel, which is Authorities tab 14, page 336 to 338, which is cited in our skeleton argument if it's more convenient than turning up the authority at paragraph 72. Is to say that where the identity of the real actors in a situation is relevant, as it is here, the court should not only can, but should identify them. I don't trouble you to turn to press now, you'll know the passage in any event, but for your note of the transcript, it's paragraphs 28, 32 and 35. But we submit that this case is a paradigm example of what Lord Sumption had there in mind.
So So who are the real actors in your... Are they the individuals? Or?
The individuals in VietJet.
So the real actors are Madam Town, Dr. Fong.
Yes. Insofar as the manipulation of the real human actors are there, and behind them or above them sit VietJet.
But if one's going to apply Lord Sumption's dictum, the real actor has to be VietJet, and one simply comes back to the attribution question.
Yes.
It's not enough just to describe those two as the real actors in the sense that Lord Sumption was using it.
No, that's why I said it involves VietJet as well.
So we're back to the attribution question.
We are, which is purely a question of fact, as reached by the judge based on all the material that was in front of him.
Yes, but that's why I say we need to focus on the
Yes.
what is the extra, as it were, by way of fact, other than they were also in the building blocks, hypothetically, individual shareholders bringing their own claim in the real world behind
Exactly.
Silver Star and Polar Star.
Exactly.
You're going to identify that.
Would you like me to do that now?
Well, no, just in the course of your submissions. I'm sorry to have interrupted. I wanted to see the extent to which you said 279.6 got you home, which you seem to be saying.
Yes.
And I was just rowing back from that a little.
This will take a little time. Can I take you, please, to the judgment, first of all? Maybe the most convenient way to deal with this. And if I can take you, please, to paragraph 377 to start with.
And Ms. Lisak, isn't it that last sentence of 377, which seems to be saying something different from the shareholder point earlier on, and then the sets of circumstances in the following paragraphs?
Yes, it is. And the extent to which I need to deal with this orally, I'm in the court's hands. That is the short summary of the point. That's where the judge sets it out. I mean, you have, in addition to 377, the run-up to it, if I can put it in that way, which begins with 375. Comes then to 377, and then, as my lady says, it's in the succeeding paragraphs where the learned judge deals with the other conduct, which he says informs his view as to the egregious campaign that was run by VietJet in these circumstances.
So, unpicking that, is it one paragraph 375 that there was the passing of material, VietJet owned material, to the shareholder?
Yes.
Two, the extraordinary timing of the replacement shareholder in 378.
Yes.
And three, that it was in the interests of VietJet to achieve the relief which the shareholders were seeking.
Yes, and but it would be to ignore reality to conclude otherwise. And then 380 onwards, he deals with the correspondence, which was quite detailed, passing between and on behalf of VietJet and Dr. Phuong and Madame Tao and the various authorities in Vietnam dealing with the export of the aircraft, which attempts to make it Australia.
Right. But that's export.
Yes.
And at that stage, there wasn't, if I understood correctly, any injunction preventing interference with export as opposed to registration.
Well,
or is that a matter of contention?
It's a matter of
That's
contention.
a matter of contention.
It's a matter of continuing contention. the matters that started with the order from Mr Justice Bryan then developed a life force of their own through other applications to clarify, expand or explain the terms of the original prohibition.
Yes.
And it continues to be a matter of controversy.
But if I understood correctly, it wasn't until Mr Justice Foxton's order the following year that interference with export was explicitly identified.
I think that's correct.
Is that right?
Mr Justice Fox, I think, forgive me if I paraphrase from memory inaccurately, taking the view that that was hitherto implicit could helpfully be made explicit.
All right. Thank you.
Is there anything else I can assist with?
Thank you.
May I notionally finish? And may I just read this?
Certainly.
Thank you very much indeed. I think it's the answer to the court's question of earlier on. Thank you very much indeed. Thank you. Subject to coming back at 2 o'clock.
Do you want to deal with that now?
Oh, may I? I didn't want to turn my back on the court.
No.
Okay, thank you.
That would be much more convenient.
The answer on judgments or orders, I'm told, and I'm sure rightly, but I don't have anything in front of me that I can now turn to. Volume 2 of the White Book, 9A, 59.3, deals with what's meant by judgments or orders. I'd like to look at that myself before advancing with any greater positivity.
Thank you.
And the other point that I'm reminded of, which and I can give you a reference to this, I know it appears in our submissions, that an officer under of a Vietnamese company has responsibility to ensure that VietJet complies with the consent order of Mr Justice Bryan, and bringing proceedings as a shareholder would constitute a circumvention of that duty that they owe.
And what's the basis of that?
I need to just find the reference to it. It's the second posted.
Shall we resume at 2
well-known
o'clock?
authority in this and every other court, I'm sure.
Shall we resume at 2 o'clock?
Certainly, yes. Thank you very much.
Thank you.